Judge, I believe we've resolved our case.
Okay, do we need to go on the record?
Yes, ma'am, please.
Okay. Ms. Taylor, can you hear us?
Yes.
Judge, it's been a pleasure working with Ms. Taylor as well.
That's wonderful. I'm glad you guys resolved it and quickly. Let's get it on the record and then we can get her on the way. Let me see, who just joined from the Samsung SM?
Tamia Russell.
Okay, give us just a moment, Ms. Russell. Do you have an attorney?
No, ma'am.
Okay. In just a moment, I'll get you in the room with Mr. Cyber, okay?
Thank you.
On the record in the matter of Edgewood Villas versus Italy Taylor, file number is 22-03864 LTE. Appearance, please.
Tom Siver on behalf of the plaintiff.
Thank you. I sent you a request to start your video, Mr. Cyber.
Oh, I thought we did. I'm sorry. There we go.
Okay. Okay, and Ms. Taylor, if you can adjust your screen for us, please. Thank you. Today's the date and time that's set for a hearing on a non-payment of rent. Are the parties met privately? Ms. Taylor, you are without counsel and you're waiving your right to counsel today, correct?
Correct.
Okay, Mr. Cyber, can you put the terms of the resolution on the record, please?
Yes, Judge. Did we pay for a money judgment?
It says that you did have a supplemental complaint. It just didn't say what the amount was.
Yes, ma'am.
that you
Okay.
received.
Judge, we have $8,395.34 plus court costs due and owing. Ms. Taylor has agreed to the entry of a judgment with 30 days of in order to vacate the property. Ms. Taylor, do you know what your rent number was? I apologize.
No.
You don't know how much you pay per month in rent, ma'am?
I think they moved it to like $8.59.
Okay. Judge, I'll do a proration here real quick.
Let me see, what is today's date?
Today, I believe, is the 15th, the Ides of March.
Okay, so she has until April, well, April 15th is Saturday, April 15th to vacate.
Yes, ma'am.
The writ date will have to be the 17th.
So the number for the rent for money judgment, 99.11459 would be $7,951.99 plus court cost, Judge. So it would be 205 plus service. I don't know what the service is because I didn't receive that from Mr. Ramsey.
I see 3656 for service.
Yes, ma'am.
Oh, you said 205 plus service. Okay.
Yep. So it'd be 241.56 plus on the possession side would be 8395.34 plus court costs of 241.56. On the money judgment side, it would be $9,351.99 plus the 241.56.
Okay, sounds good. Okay, Ms. Taylor, so you've already indicated to the court that you wish to waive your right to counsel today. You would have to give up your right also, ma'am, to have a hearing on this matter, which was scheduled today, if you wanted to enter into consent judgment today. Is that what you want to do?
You said, excuse me, I couldn't hear you.
I said you have to give up your right to have a hearing. You had a right to have a hearing today.
Mhm.
Or you could have demanded a trial when you were served with this paperwork, but you never demanded a trial. But you had the right to have a hearing today on this matter. Are you willing to waive your hearing so that you can enter into this consent judgment?
Yes.
Okay. Anybody threatening you or promising you anything to get you to waive your hearing?
No.
Okay. So your agreement, ma'am, that you understand it to be is that you will pay the amount of $8,395.35 plus $241.56, which includes court costs and fees, or vacate by April 15th. There's also money judgment to enter in the amount of $7,951.99 plus court costs of $205 plus $36.56 for fees. You understand that?
Yes.
And you want to enter that agreement today?
Yeah.
You want to, okay. Are you also going to give Mr. Cyber permission to sign the consent judgment on your behalf?
Yes.
Okay. You have 3 business days from today. If you leave here and you determine that you misunderstood any of the rights that you just waived here on the record, you can return to the court and request to have this judgment set aside. You'd have to articulate or explain to me how it was that you misunderstood your rights. Okay, ma'am?
Okay.
Do you have any questions?
No, ma'am.
Okay, you're all set. Mr. Cyber, you can sign on her behalf.
Thank you, Judge. Thank you, ma'am. Italy, I love your first name. It's beautiful, and thank you for working with me.
Thank you. You're welcome.
Ms. Till.
I am here with
You're
Miss
welcome.
McKinstry.
McKinstry.
Yes.
Okay. Did you need to speak with Mr. Cyber?
Yes, if I could, please.
One moment. Ms. Till, did you need to meet with your client or are you all set?
I believe we're all set. We are just going to request an adjournment for a week to try and figure out some of the issues in this case between the two of us.
Ms. Till and I are going to get ledgers together and see if we can't resolve, Judge. If we can resolve, we'll submit a consent judgment. If we can't, then we'll go to trial.
Mr. We did receive an answer. I don't know if you intended to file a jury demand, but we did not receive one if you did.
I did not intend to file a jury demand. I was only intending to file the answer. I tried to make sure to take out every reference to a jury that I could. So if I miss something, let me know and I'll resubmit.
Okay, I will note here that you want an adjournment. I can say at 8:30. April 5th at.
What time, Judge?
April 5th at 8:30.
Okay, we should get it done by then, Judge.
Okay. Any additional matters on this one today?
No, ma'am.
Nothing for defendant, Your Honor.
Okay, thank you.
Can we,
Ashley, I will give you a call real quick as soon as we're done here.
yes, please.
Okay, Ms. Russell, I'm gonna add you to room 1. Mr. Cyber is already in there. You can just return there and meet with you privately.
Thank you.
No problem.
Ma'am, I believe I got this one resolved.
Let me see if I can bring her back. Hi, I'm just joined from the iPhone.
Lakila Patterson.
Okay, Ms. Russell, can you hear us?
Yes, ma'am.
On the record in the matter of Edgewood Villas versus Tamia Russell and file number 22-03866 LTE, council appearance.
I'm Cyber on behalf of the plaintiff.
Okay, Ms. Russell is present today without counsel. And you met with her privately, Mr. Cyber. Can you place the agreement on the record?
Yes, Judge. What we'd like to do is have this adjourned out to the next available hearing sometime in April. That way, not my client, but my defendant can get some of her rent caught up. And by the next hearing, we should be able to be either paid up in full or be to a point where we could look at dismissing.
Okay, sounds good. April 12th at 3:30. April 12th at 3:30.
April 12th at 3:30.
That's correct. Any additional matters today?
Not for this one, Judge. Thank you. I think Miss Russell has been an awesome person to work with.
It's been a pleasure working with you also, Mr. Cyber.
Thank you.
You're all set, Ms. Russell, unless you have questions for the court.
No, ma'am, thank you.
Thank you. Okay, let's see. Is that all you have, Mr. Cyber?
I believe so, ma'am. That should take care of my cases with you. I've been trying to get in Judge Flores's courtroom and Judge Buchanan's all morning or afternoon as well.
Are you having a technical issue with that?
I don't know. We're waiting in the waiting rooms on laptops and we haven't been invited in.
I don't hear anything going on across the hall. So Judge Flores is done for the day, so I don't think anyone's in there.
Okay. Thank you so much. Have a good day.
Same to you.
Yes, ma'am.
Okay, Ms. Patterson. Okay, Mr. Asphalt is here on the matter with Lakila Patterson. Ms. Patterson, do you have an attorney?
I don't think so.
Well, did you hire an attorney, ma'am?
No.
Okay, sounds good. So I'll get you in a private meeting room with Mr. Asphalt, and you can see if you can resolve this, okay? If not, we can proceed to hearing.
Okay.
Alrighty, okay, are we ready on Ms. Patterson's matter?
Yes, Your Honor.
Okay, we're on the record. In the matter of Woodbridge Apartments versus Lakila Patterson. This is file number 22-03885 LT. Appearance for the record, counsel.
For asphalt for the plaintiff.
And Ms. Patterson is present today without the representation of counsel. Mr. Asphalt, were you all able to come to an agreement on this?
Yes, Judge, we have the terms of a consent judgment that I'd like to put on the record.
You can proceed.
Your Honor, the parties agree that currently there's 700 and, well, let me break it down. There's $449 in rent, $155 in court costs, for a total amount of $704 is due and owing at this time. The defendant is to pay $300 by March 29, $304 by April 7, and April's rent and April's late fee by April 21st.
Okay, Ms. Patterson, that's what you understand your agreement to be?
Yes.
Okay. And so,
And-
Ms. Patterson, you, Mr. Asphalt, you had something else to add?
Yes, I was just going to add that the defendant has given me permission to sign her name to a consent judgment with those terms, Your Honor.
Okay, sounds good. So what was the final due date on this?
April 21st.
Okay, now, Ms. Patterson, you understand that you have the right to be represented by counsel today, correct?
Yes.
And you're waiving that right, ma'am?
Yes.
You also have the right to proceed to a hearing, or you could have demanded a trial. You had a right to a jury trial on this matter. Are you giving up your rights to hearing or trial in this matter to enter into this consent judgment with the terms that Mr. Asphalt just put on the record?
Yes.
Okay, anybody making any threats or promises to you to get you to waive your right today and enter into this agreement?
No.
You have 3 business days from today. If you leave here and you determine you misunderstood your rights, you can return to the court and request to set aside this judgment. You would have to articulate how you misunderstood your rights, okay, ma'am?
Okay.
And it is true what Mr. Asphalt said, that he can sign your name to the agreement with your permission?
Yes.
Okay, do you have any questions?
No.
Any additional matters today, Mr. Asphalt?
No, I believe this is the only one, Judge.
Thank you, you're all set, ma'am. Thank you, Mr. Asphalt.
Thank you. Have a
Thank
good
you.
day.
What's your name, ma'am? Oh, should I do that?
Melinda Adam.
Your case was dismissed, ma'am. You're all set.
Thank you.
No problem. Mr. Joseph,
Hey, Judge.
Therese, hi again. Let's see here. Teresa Martin failed to appear.
Okay.
So you can submit default.
All right. Very good.
Thank you.
Thanks.
but I got all the buildings done since yesterday.
Ms. Till, I don't know which matter you're here for.
I am here for Melinda Adams at 3:30. I believe that case may be dismissed, but I just wanted to double check because it's not dismissed on the ROA yet.
Yeah, I have that it was dismissed.
All right, perfect. Well, then I will go ahead and let my client know and just go ahead and log off. Thank you.
No problem, thank you. Victoria Young,
Yes, ma'am.
okay, start your video, please.
Yeah.
Do you have an attorney?
No, I don't.
Okay, Mr. Joseph, are you able to meet with her at this time? Mr. Joseph? Mr. Joseph?
Yes, sorry, Judge, I had to step away and use little boy's room, so I apologize. I didn't realize you guys were trying to get my attention.
Yes, we wanted to see if you wanted to meet with Miss Young.
I don't think that's gonna be beneficial. We've already spoken several times and I've been told that there's no agreement, so I'm fine moving forward with the hearing. Unless she wants to talk. If she wants to talk, I'm happy to discuss it.
That's up to her. Ms. Young, did you want to have a discussion at this time? Or this is the one I need, the police report, is that what it was?
Yes,
Mhm.
Oh. Okay, actually, and I don't think I requested, but I think that the responsibility is not on me to get that taken care of. It might have been yours, Mr. Joseph. Let's see.
I think there was a redacted copy which we were able to give, and I think defendant had, but the court advised it would seek an unredacted copy.
Yeah, I did, and then I reviewed this file. The issue is the way it was the way the case is filed. You're trying to rely on a the type of eviction being that of a termination of tenancy due to a health hazard. Is that what you were claiming?
Wellness, I think that's how it was filed.
Right. You were responsible then to file a copy of the police report with the summons and complaint. I don't have a copy of the police report. I don't have to go seek it out. You're claiming that, so you need to provide the unredacted copy for the court.
Okay, I believe we filed it with the redacted copy, and I don't know we were able to get an unredacted copy.
Yeah, there's no copy at all. The first of the police report that I've heard, or that this involved a matter that had a police report, was when she emailed the police report to the court. I don't have anything attached, any exhibits attached to this, except for her lease.
Okay, so we need to get you an unredacted copy now. Is
Yeah.
what
Either an unredacted copy, or you're gonna have to subpoena some witnesses to a hearing.
okay, so yeah, that sorry, Judge, it was different what we discussed at the last hearing. I'm happy to do that though.
Yeah, after I got off the bench from this file last time, I reviewed it and I realized there was never a copy of the police report even filed with the complaint. And that would be the first step in stating that there was a safety issue at the home. If that's the type of eviction you want to rely on here. I do see a section F that it says that there was a lease violation, gas shot firearm on premise. She's indicating that was not her unit. So the burden would be on you to determine that that was her unit and that there was a police report that indicated that.
So we can set this then for a trial date where witnesses would be present, and we can. Is that what the court's thinking?
Yes, I can set it out.
Okay, that's fine.
Well, it's just a hearing. They didn't demand a trial. No. I don't know how far we need out, but we can do April 26th. April 26th at 1:30.
All right.
Okay, do you have any questions today, Ms. Young?
No, I do not.
Okay, we'll see you on April 26th.
Okay.
Okay, and then Ms. Till.
Yes, I apologize, Your Honor. I believe that we had also entered an appearance for Miss Teresa Martin at 2:45.
Okay, well, that would be why she didn't appear. Let's see.
Okay.
Do we have an appearance for her? I didn't see one.
Okay.
They should. Yeah, they should.
Ms. Pereira's name on it, but no actual appearance in the file.
It looks like we don't actually have an appearance in the file. We just had a stip in order signed by Ms. Pereira.
Okay, got it. All right, then. Would we be able to get an adjournment in that case?
Okay, so you're gonna file an appearance on that one?
Judge, as a courtesy at the last hearing, I agreed to stipulate to an adjournment so that that could be done. And now it hasn't been done and there's been no progress. So we would object to any further adjournment in this matter.
I don't know what happened. I received a stip in order here. It says it was mailed to all parties. You all signed that on the 28th. It wasn't at a hearing.
Oh, I'm sorry. Yes, it was prior to, I'm sorry, this was set for hearing for March 1st. And
I understand that, but
Yeah.
and then Ms. Till wasn't even the one who signed this, so I can see why she may have thought that that was taken care of. So I recognize that you're objecting, but I'm gonna grant Ms. Till an opportunity to file an appearance because Ms. Pereira was the one who handled this, not Ms. Till. If they're gonna be a stip in order, they should have been an appearance with the stip in order, but we just have the stip in order. It's really a small technical issue at that, because obviously they've appeared on here because they've stipped to an adjournment. So we just need a formalized appearance from her, and I'm assuming you all will try to work through some agreement. Us adjourning this does not preclude you from doing that.
yeah, I understand. I did realize it was a different attorney, so I certainly wouldn't want to put Ms. Till behind the 8 ball on this, so that's fine.
To April 19th at 2:30. April 19th at 2:30. Any additional matters on this one?
No, Your Honor, I will get you an appearance post haste.
Thank you. We did make sure you're young, didn't we? Or did I miss that? Yeah. I didn't cross it off of my sheet. Okay, I see Henry Lee. Brett Ingram is here. The matter with Phyllis and Phyllis, they failed to appear. You can submit default.
Very good. Thank you, Judge. And that should be it for me this afternoon. You have a good afternoon.
Same to you. And then Mr. Lee. Henry Lee Wells. Oh, he hasn't started his audio, that's the problem. Let's hydrate it. Doesn't want to start his audio. Let's video.
Hello.
I can't hear y'all.
Can you hear me, sir?
Yeah,
Hello?
no.
Okay, very good. Do you have an attorney?
No.
Mr. Wells? Okay, I'm gonna put you in the private
Yes.
meeting room with the plaintiff's attorney, okay?
Okay.
Is it Wesley McCoy?
Hey, how you doing today?
I'm good, how are you?
All right.
Okay, do you have an attorney, sir?
You said, do I have a, oh, excuse me, sorry about that. You
Do you
said, do
have
I have
an
a,
attorney representing you?
no, ma'am.
Okay, you hang tight, we'll get you in the private meeting room with the plaintiff's attorney, okay?
All right, thank you.
No problem. Mr. Wells, you need to go into the breakout room.
You can see me on your computer.
Excuse me?
I was like, you can see me on your computer.
I can see you on my computer, yes.
Okay.
I also have a screen on my wall. I can see you on there too.
Now, when you looked at the wall, I was I was wondering, could you see me on the computer too? I look terrible because I was hoping you was going to see me on the wall. Ah, Jesus. Life of a working man. Anyway, I look terrible in camera. I need a filter. I need Snapchat filter.
Okay, Mr. Joseph, are you ready to proceed?
Yes, Judge, we are.
Okay, we're on the record in the matter of Edward Rose Associates versus Henry Lee Wells, file number 22-03952 LT. Appearance, please.
Thank you, Judge. Joe Joseph for plaintiff.
Okay, Mr. Wells is present without an attorney. Mr. Joseph, how are you proceeding?
Thank you, Judge. This time, we have agreed to a consent judgment of possession. The total amount that is due is $3,782.85 plus the court costs of $169.16, totaling $3,952.01. We've agreed to that amount with a writ to issue after the 31st if it is not paid. Mr. Wells has consented to having me sign his name to this judgment. I've gone over his rights under 4.201 regarding a 3-day rescission rule, and we're asking the court to allow this judgment to enter as proposed.
Mr. Wells, are you still there? I don't know if he's still here. He's having some
He was having connection problems. He got to a spot wherever he's at where it worked pretty good. So I don't know.
Yeah, it's telling me now that he doesn't have any audio.
Okay. Maybe he can call in.
He actually could, but I don't think he can hear us in order to do that. I don't know if you have his number, but we do not.
Yeah, I don't. I don't think. Yeah, I don't.
Looks like he logged back in.
I'm hoping don't happen to me.
Well, Judge, I can speak with Mr. McCoy while we wait to see if we can connect with Mr. Wells.
Yeah, you can see me?
Yeah, we can see you.
I'm not talking to him. I'm not saying it like that. Sorry. The camera keeps switching. Oh, okay.
Let me put you in the room with him.
Join. Okay.
Hello?
Yeah, my connection sucks. I'm sorry.
I understand, sir. We hang tight, and if you can get your connection to stabilize, you should stay there. I'm gonna wait for Mr. Joseph to return. I'm also gonna stop your video because that might help your connection, okay?
You said what? Mhm.
Hello?
Yes.
Okay, Mr. Joseph, I have Mr. Wells back. Mr. Wells, did you hear the terms before you got cut off of your agreement?
Yes.
Okay, so the agreement is by consent judgment for you to pay the total of $3,952.01 and or vacate by March 31st. That's what you understand your agreement to be?
Yeah.
Okay. And you want to give up your right to be represented by counsel in order to enter into consent judgment?
Yeah.
That's a yes?
Yes, ma'am.
Okay, and then you want to give up your right to have a hearing on this matter and also to enter into this agreement, correct?
Yes.
Okay, you have 3 business days from today. If you leave the court and you determine you misunderstood the rights you're waiving in order to enter into this agreement, you can request to have this agreement set aside if you can articulate how it was you misunderstood your rights. Lastly, have you given the attorney for the plaintiff your permission to sign your name to the agreement?
Yeah.
Okay, do you have any questions today, sir?
You said I got 3 days to do what?
3 days to return to the court. If you leave this courtroom today and you realize that you misunderstood the rights that you are waiving in order to enter into a consent judgment, because you had the right to have a hearing in this, and you had the right to demand a trial, and you had the right to be represented by an attorney. But you're giving up those rights today in order to enter into this agreement, correct?
Okay. Yes.
So if you leave here and you determine that you misunderstood any of the rights that you're waiving and you want to have this judgment set aside, you need to do that within 3 business days, okay?
Okay.
Okay, do you have any other questions today?
No.
Okay, any additional matters, Mr. Joseph?
Nothing further, for plaintiff. Thank you.
Thank you, you're all set, Mr. Wells.
Thank you.
No problem. On the record in the matter of Edward Rose Associates Incorporated versus Wesley McCoy. File number is 22-03956 LTE. Appearance counsel.
Thank you, Judge Joseph, for the plaintiff.
And then Wesley McCoy, you do not have an attorney representing you today, correct?
No, ma'am.
Okay, so today was the date that was set for your hearing on a non-payment of rent. Mr. Joseph, did you all come to an agreement?
Yes, Judge, we have. If I can place those terms on the record.
Please do.
Thank you. We've agreed to a consent judgment of possession. There's a total balance of $3,451.74 plus cost of $169.16, totaling $3,620.90. That will be the amount of the rent to retain with a writ to issue after the 31st if it's not paid. And Mr. McCoy has been given his rights under 4.201 regarding the 3-day rescission rule. And he's also consented to having me sign his name to this judgment.
Thank you. Mr. McCoy, is everything that you're hearing accurate?
Yes, ma'am.
Okay, so you're gonna pay the amount of $3,620.90 on
Yeah.
or before the 31st of this month, or vacate by that date?
Yes, ma'am.
Okay. And you're willing to give up your right to be represented by counsel today in order to enter into this agreement?
Yes, ma'am.
You're also giving up your right to have a hearing today. You want to give that up in order to enter into agreement?
Yes, ma'am.
Are you being threatened or any promises being made for you to waive those rights?
No,
What's so funny?
I ain't been threatened in a long time.
Oh, okay.
Yeah.
Okay, sounds good. And you have
No,
three
I'm not
business
being
days, sir.
disrespectful. I'm sorry if I am. Sorry.
I'm sorry?
No, if that was right rude or disrespectful, I apologize.
I know, I mean, it was honest. I asked you, were you being
Yeah,
threatened?
okay.
So you were being honest. Ain't nobody threatening Mr. McCoy, so.
Yeah, no.
I get it. So, Mr. McCoy, you have 3 business days from today. If you leave here and you determine that you misunderstood the rights that you're waiving, and you can request to have this agreement set aside. And
Yeah,
lastly,
no,
could you give
I'm fine. I'm cool.
Okay, sounds good. And
I owe
you've
that
given
money.
Mr.
I gotta
Joseph
pay it.
permission to sign. You've given
Huh?
Mr. Joseph permission to sign the agreement on your behalf.
Yes, ma'am.
Okay, do you have any questions, sir?
No, not at all.
Okay,
And
any
it's
additional
wait,
matters?
I got to the 31st, you said, right?
You have until the 31st to either pay that amount or vacate the property.
Okay, yeah.
Okay,
Yeah.
Mr. Joseph,
Yes,
anything
yes.
else?
Nothing further from plaintiff. We'll get that judgment to the court.
Thank you. You're all set, Mr. McCoy.
All right, thank you. You have a nice day.
You
Same
too.
to you.
I think that's it, Judge. I don't think I have any further with you.
Yep, that's all we have today. Thank you.
All right, have a good one.
You too.